Now let's talk about right to equality. And in this segment, we'll talk about 5 important fundamental rights from Article 14 to Article 18 of the Indian Constitution. Now let's look at Article 14 of the Indian Constitution. Now first up, how does the text of Article 14 look like? Article 14 states that the state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. That means 2 important phrases are talked about in this article. Equality before law and equal protection of the laws. Now, both these phrases are different. Equality before law and equal protection of the laws do not mean the same thing. Equality before law is different from equal protection of the laws. But the underlying principle of equality means that like should be treated alike. If I am different from another individual, if we are not equal in all respects, we should not be treated equally, but we should be treated unequally. Confused? To remove your confusion, let's look at both these phrases one by one. First, we will look at equality before law, then we will talk about equal protection of the laws, and you will understand what is the difference between the two. Article 14, when it talks about equality before law is the second corollary of A.V. Dicey's rule of law. A.V. Dicey was a constitutional expert in Britain. He crystallized rule of law. Now, what do we mean by rule of law? 3 principles. Principle number 1, nobody shall be made to suffer in body or goods except for a breach of law. That means no one should be made to suffer. If I am a citizen, I shall not be deprived of my life. I shall not be deprived of my property if I have not violated any law of the land. It means without violating any law of the land, I shall not be made to suffer. Rule of law equal. Rule of law, principle number 1. Principle number 2, a person can sue or be sued. I can sue you, you can sue me. We are equal in this respect. There shall be no discrimination in this case. You can sue me, I can sue you. I can file a case against you, you can file a case against me. No difference. Third, Constitution is the result of the ordinary law of land. But we know A.V. Dicey of Britain. Now we know A.V. Dicey, a British individual, is talking about in context of UK Constitution, which is an unwritten constitution. In unwritten constitution, there is no distinction between a constitutional law and an ordinary law. But this third principle of rule of law we have modified in India, where we say constitution is not the result of the ordinary law of land, but constitution is the supreme law of land. But nevertheless, rule of law means no person shall be made to suffer in body or goods if he has not violated any law of the land, and anybody can sue or be sued. Before rule of law, the principle or maxim was rex lex. That means king is the law. King was the judge, jury and executioner. Who was making laws? King. Who was implementing laws? King. Who used to provide death sentence or other punishment to its subjects? King. That means before rule of law came into picture, the maxim was rex lex. King is the law. After rule of law, the maxim changed. It became lex rex. Law is the king. That means when we talk about equality before law we have borrowed from the British, and it is viewed as a negative concept. Nobody shall be made to suffer. It means it's a negative obligation. To explain this simply, what does equality before law mean? Equality before law means, number 1, absence of any special privileges in favor of any person. No special privileges for me. Whether I am a Hindu, or I am a Christian, or I am from upper caste or a lower caste. or I am rich or poor. No special privileges on this case. Everybody is equal. No special privileges because of who you are or where you come from. No special privileges, number one. Number two, equal subjection of all persons to the ordinary law of land. I have committed murder. I shall be tried under section 302 of IPC, which is a section for murder. Now, I have committed murder. Another individual has committed murder. Whether he is of my caste does not matter. Whether he is of my class does not matter. Whether he is of my religion does not matter. We both will be subjected to equal laws. That means for murder, we both will be tried under section 302 of IPC. Third one, no person is above the law. This is what do we mean by equality before law. To summarize, equality before law is supposed to be a negative concept, and we have borrowed it from the British Constitution or British. Equality before law is the second corollary of rule of law, which was crystallized by A.V. Dicey. And to simply understand rule of law, we mean that no one shall be preferred at the expense of the other, regardless of who he is, regardless of where he comes from. Anybody can sue or be sued. Everybody is equal in the eyes of the law. This is equality before law. But when we say no person is above the law, this is what we mean by equality before law. There are also exceptions. Now let us look at the exceptions of equality before law. Exception number one, president or governor is not answerable to the court of law with regard to the discharge of their official functions. That means if there is a president or a governor, they have committed crime, they have committed gross violations while they were in office. Despite that, no charge can be leveled against them. Despite that, they are not answerable to any court of law while they are in office. This is because of the maxim which was prevalent in England. King does no wrong. That means a president or a governor is not answerable to any court of law while they are discharging their official duties or while they are in office. We also saw a glimpse of it. A particular governor in Andhra Pradesh, Mr. N.D. Tiwari, was accused of sexually exploiting women. But no criminal action could be taken against this particular individual because he was provided with immunity. Immunity provided by the Constitution itself. Ultimately, he was forced to resign and then charges were leveled against him. But while he was in office, no criminal action whatsoever could be taken against him because he enjoys immunity or he enjoyed immunity. That also means no criminal action can be taken whatsoever against the president or a governor so long as they remain in office. Third exception, no civil proceedings in which compensation or relief is claimed can be filed against a president or a governor. Now I am a president or a governor. You have to file a case against me. Why? Because I have to provide you some compensation or I owe you something for which a relief is what you are claiming from me. You cannot file a case against me. You can give me a notice that within a period of 2 months, please provide me compensation, please provide me relief. And the governor or the president, you are asking for relief from me or compensation from me. This is a civil case. I owe you something or whatever that may be. This case cannot be filed against me. But this case can be filed against me if you give me a 2-month notice that within this 2-month period, you settle my compensation, you settle my claim. Even after that, if I do not settle your compensation or claim, then you can file a case against me. But in criminal case, no case can be filed against me, no matter what the charge is, no matter how serious the charge is, because of the maxim that was prevalent in England at that point in time, to protect the honor of the office. And again, visiting heads of countries and foreign diplomats are not answerable to the courts of India in discharge of their official functions. Now we saw an interesting case. A particular diplomat from Saudi Arabia was residing in India. While he was residing in India, he was also sexually exploiting his maids, the Nepali maids. And what happened? There was furor in India. But this particular diplomat was not arrested. No case was filed against this particular individual. Why? Because of diplomatic immunity. Because of the fact that these foreign diplomats are governed by Vienna Convention on Diplomatic Relations, 1961. Now let's talk about this convention very briefly. It's an international treaty that defines framework for diplomatic relations between independent nations. It specifies the privileges of a diplomatic mission that enables diplomats to perform their functions without fear or coercion or harassment by the host country. And there is something called Vienna Convention of Diplomatic Relations, 1961. India is a signatory to this convention. Now what this convention does, it specifies the privileges of a diplomat. If I am a diplomat, what are the privileges that are enjoyed by me? Why do we need privileges? Because of the fact that I should not be threatened by the host country. If I am an Indian diplomat in Germany, I have to perform my duties. But I should be able to perform my duties without any fear or coercion on part of the German authorities. I should be able to perform my duties without having this at the back of my mind that Germany might do something against me. Without any fear or coercion, I should be able to discharge my official functions. This forms the basis of diplomatic immunity. Now, there are some 53 articles in Vienna Convention. Article 9 talks about something very important. Now, we say that a particular diplomat, for example, I am an Indian diplomat and I work in Italy. Now, I am a diplomat. I am governed by Vienna Convention on Diplomatic Relations. I can do whatever I want to do and no case can be filed against me in Italy because I enjoy diplomatic immunity. Now, does that mean I can commit murder? I can commit sexual exploitation? I can commit rape after rape without being subjected to the ordinary laws of Italy? That means this particular convention can be violated, but then there has to be a solution. And that solution is provided by Article 9. In this case, if I have violated the laws of Italy, host country, which in this case is Italy, Italy can declare me as persona non grata. And if Italy declares me as persona non grata, within a specified time, I have to leave Italy. Otherwise, I will be arrested by the Italian authorities and I will be subjected to the laws of Italy. Article 9 of the Vienna Convention. Article 22 of the Convention, another important article that we have to discuss. It talks about the premises of a diplomatic mission, such as an embassy, are inviolate. I'm a diplomat, an Indian diplomat in Italy. In Italy, we have an embassy. This embassy is inviolate. That means police of Italy cannot enter this embassy without the permission of the head of this mission. That means we have an embassy in Italy. It is headed by an individual. Without the permission of this head, the Italian police authorities cannot enter into the embassy. That means this embassy is inviolate. This particular extension, this particular immunity is also extended to the private residence of the diplomats under Article 30. What we saw, WikiLeaks founder Julian Assange. He was accused of sexual exploitation by Sweden authorities. Ultimately, what happened? An arrest warrant was issued against him. And what he does, he was in London. He was accused of sexual exploitation. An arrest warrant was issued against him. He could have been arrested. Now what he does, he quickly sneaks into Ecuadorian embassy. Now this Ecuadorian assembly is inviolate. The England police cannot enter into Ecuadorian assembly and Julian Assange could not be arrested. Now, police were outside this Ecuadorian assembly looking for that moment when Julian Assange would step out of this Ecuadorian assembly and police will arrest him. But police cannot enter the Ecuadorian embassy without the permission of the head of the mission. Not just this. Maldives President Mohammed Nasheed, he alleged that he was toppled by the military government, or he was toppled by the military. Now what he does, he runs into Indian embassy and seeks asylum inside Indian embassy. Maldives army or Maldives police could not enter into the Indian assembly because Indian assembly or Indian embassy is inviolate. It cannot be entered into by the police or military. That is the protection which is given by the Vienna Convention to these diplomats, primarily because of the reason that these diplomats should be able to perform their function, should be able to satisfy their role without the coercion of their host countries. Now let's briefly summarize what do we mean by equality before law. Number one, no special treatment to me, regardless of the fact who I am, where I come from, what my religion is, what my caste is. No special privileges. Equal subjection to all laws of the country. And nobody is above the law. But when we say nobody is above the law, there are some exceptions. Exception number one, president and governor. No case can be filed against president or governor while they are discharging their official duties. Exception number two, no criminal case whatsoever can be filed against a president or a governor while they are in office. Exception number three, no civil proceedings can be filed against a president or a governor unless the expiry of 2 months notice to them. And at the same time, there is diplomatic immunity which is provided to the foreign diplomats in India, which is governed by Vienna Convention of Diplomatic Relations. This is equality before law. Let's look at equal protection by the law. This concept originated in the US Constitution and it is described or viewed as a positive concept. Now, what does that mean? Can absolute equality be possible in this world? No. Why? For example, I am an individual. You murdered me. Now, does that mean when my parents will file a case against you, you and me will be on the same footing? You and me will be treated equally by the government or by the laws of this country or by the judiciary of this country? I am a victim, you are my murderer. That means when we say equal protection by the law, it only means that equality of treatment in equal circumstances, not equality of treatment in unequal circumstances. To explain this further, equal protection by the law, what does that mean? Income tax that you and I pay and other individuals who are paying. Some people pay 10% income tax, some pay 20%, some pay 30%. If everybody is equal in the eyes of the law, why this discrimination? But equal protection by the law means equality of treatment in equal circumstances. That means those individuals who earn above a certain limit, they have to pay this much tax. And those who are poorer, they do not have to pay tax. Or those who earn lesser amount of money or minimum amount of money, they have to pay a specific percentage of the tax. That also means that equality of treatment in equal circumstances, not equality of treatment in unequal circumstances. That means if I have committed murder, you have committed theft. You and me cannot be treated equally because you have committed theft, I have committed murder. If you have committed murder, I have committed murder, then only we can be treated equally. That means likes are to be treated alike. Equal protection by laws also mean and also talk about the fact that people are with different talents and they need special provisions to develop their talent. Now, what does that mean? That means it requires affirmative action by the state towards unequals by providing facilities and opportunities. That is what we are talking about in equal protection by the law is substantive equality and distributive justice. Now, what does that mean? That means there are two classes of people. One class of people are equal, the others are not equal. One class of citizens are socially and educationally backward. The other class of citizens are socially and educationally developed. Now, can we treat both these classes equally? We cannot treat them equally because that will be against equal protection by the law. What we can do? We can uplift those individuals who are socially and educationally backward. That means substantive equality is to be provided. Or we can distribute the resources of this country amongst the unequals. We can distribute the resources of this country to those individuals who need it. That is distributive justice. That is reservation policy of the government, wherein reservation is provided to SCs, STs and OBCs. It is not violative of Article 14 of the Indian Constitution. Because we can talk about equality only when there is equality in the society. When we began, we were not equal. When we began, we were unequal. Another point to be noted here is that what Article 14 prohibits is class legislation. What does that mean? Legislating for a particular class, legislating for rich, legislating for poor, legislating for men, legislating for women, this is not allowed. Class legislation is not allowed. But what is allowed is classification for the purpose of legislation. To explain this further, for example, there are people who are socially and educationally backward. Equal protection by the law states that we should make laws for them so that they are uplifted. But how can we make laws for them? First and foremost thing is we have to identify who these socially and educationally backward citizens are. To identify them, we can classify them. When we can identify who are these socially and educationally backward citizens, first we can identify them, then we can classify them. Then we can classify them for what purpose? Only for the purpose that we have to legislate for them so that they can be brought up. What does that mean? Equal protection by the law means that like should be treated alike. There should be equal treatment in equal circumstance, or equality of treatment in equal circumstance, not equality of treatment in unequal circumstances. So what is it that we talked about in Article 14? Article 14 talks about equality before law and equal protection by the laws. Equality before law, an English concept, a negative concept. Equal protection by the law, a US concept, a positive concept. Equality before law means everybody is equal before the law. That means no one is above the law. And no special preferences, no matter where I come from, who I am, what my class is, what my caste is, what my educational qualification for that matter is. That means no special preferences will be given to me. This is equality before law. Then there are exceptions which we have talked about. Equal protection by the law talks about a very beautiful concept wherein it is clearly remarked that it may not be possible to have absolute equality in this country. Some individuals are to be treated differently. Why? Primarily because of the fact that they are not equal to others. Primarily because of the fact that they are backward and some are so-called forward individuals. These backward individuals are also to be supported by the government. Then we can talk about justice, then we can talk about equality in this country. So affirmative action policy, reservation policy is completely valid within the meaning of Article 14 of the Indian Constitution. What Article 14 prohibits? It prohibits class legislation. That means legislating for a particular class. But what it does not prohibit is legislation or classification for the purpose of legislation. But when you classify people into socially and educationally backward classes of citizens, this classification is to be done on a reasonable basis, and this is subject to judicial review. That means judiciary will review whether this classification is reasonable or not. So this is about Article 14 of the Indian Constitution.